I'm a partner in the Chicago office of Akerman. I co-chair the firm's data law practice, which covers everything from privacy security through information data governance to electronic discovery. It's all of the issues that pop up when computers meet the law, meet lots and lots of data. So I joined Akerman about 3.5 years ago, largely to launch and help co-chair this practice, but also because Akerman had just recently launched a Research and Development Council, which was a joint effort between the firm and clients to figure out, to find these opportunities to build new mousetraps, and it was very appealing to me. When I moved, when I joined Akerman, it was still with the expectation that I was carrying over a traditional practice. I was going to be doing 1,700 client billable hours a year, and maybe have some opportunities to get involved in the innovation. Well, fast forward 3.5 years, today less than 20% of my time is traditional billable hour, advising clients and billing for rate times time. The other 80% has been in the building new mousetrap space, which I have loved, but I wanted to explain sort of how I got there, because the path into this sort of innovation practice actually came out of a very ordinary client request and a need at the law firm to meet a client's need that, frankly, the law firm wasn't well positioned to meet, and the issue was, we were doing a privacy program, incident response plan, pretty basic stuff for a client. The client asked us if we, Akerman, could do for them as part of that project build for them a living database, they called it, but they wanted in the US, all 50 states have their own data breach notification statute. So they wanted us to build this inventory for them and then keep it current on a go-forward basis. And I said, yes, we could do that, but frankly, at associate billing rates, et cetera, it's going to be expensive to have us do it. And if law firms are candid, they're not especially well equipped structurally to for the ongoing maintenance, because you have associates that will cycle through doing research, people have trials come up, even the most well-intentioned law firm will get derailed. So what that took us to was a partnership with Thomson Reuters, unrelated to the technology, but leveraging managed services attorneys to do that first tier of regulatory research. TR has an entire division within their managed services that does large-scale regulatory research projects. We partnered with them and took $80,000 or $100,000 worth of law firm work down to maybe 25 or 30 with this model. And then where Neotologic came in was then we had to deliver this to the client. Then again, thinking about the traditional law firm deliverable for a project like that, it's a big memo or set of charts or a bunch of statutes in a binder, and all of which are historically fine. But still, when the reason they wanted this, they didn't need the research just to have all of the laws. They needed the research because when something went wrong, somebody was going to be knocking on a door saying, what do we have to do? So those traditional deliverables are all the one-to-one model where somebody still has to pull out that research and walk through 50 states, look at the rules, and figure out how they apply to the facts. So anywhere from a few hours to several hours done in that traditional one-at-a-time way. What Neota offered, and a lot of stars aligned. I'd just been looking at Neota, looking for use cases for it when this opportunity came up. What Neota allowed us to do is to build that expert system where I like to think of it as taking all of these decision trees that every lawyer has in his or her brain, and that's what we use to advise clients. Take them out of the lawyer's head, build them into logic, build them into a program that can, a lawyer can talk to and think about one client at a time. Software can work with 1, 10, 100, or 1,000 clients at a time. And so what we were able to do then by building all of the rules from that research into an application was build a tool that can take a client give a client actual legal advice, because it's our questions, it's our answers, it's all the same things that I would ask if a client called and we talked through it on the phone. And it can actually deliver in an automated fashion, 5 to 10 minutes, legal advice. So that was, that was where I veered off then. And we had this great great product that we were able to take out and show clients. Clients really liked. We got a super awesome blog post from Dan after we showed him a demo of it. But then it got even more exciting. If you can't tell, I love this stuff. But it got even more exciting when we started showing this to clients, because the response was typically twofold. It was, that looks awesome and it makes great sense for the use case that you've built. And so some of the privacy security types at clients very much interested that are using it now. But more exciting was almost every company that we meet with will say, here's 1 or 2 or 5 other pain points where we've got this similar, structurally a similar problem. We have to keep up with 50 states' rules on something, and we don't law firms can't do it cost effectively, and it's a pain in the butt when we have to pull out a big Excel spreadsheet and have somebody go linear through it and figure it out. So I've got a list now, it's got to be 45 or 50 other use cases that have been suggested to us. And so bringing it all the way back around now to this, to Dan's class here and the student teams, the projects that I gave to Dan and Jordan back in November, December, whatever it was, were actual use cases that had been suggested or asked of us by clients. So the IP, the cease and desist project, we were meeting with the deputy general counsel at a large insurance company. He was deputy GC for IP. One of his big pain points, I still don't understand why as the deputy GC he was drafting these letters himself, but he was drafting at least some volume of these letters himself, and he'd actually tried to have a solution built internally. And I mean, this is a Fortune 10 company, all the resources in the world, and he couldn't get it done. And this is a common thing that we find with clients. It's hard for legal to get the attention of IT on purely internal, non-business facing problems. So he said it would. I think this is the issue, both the analysis and then the drafting, the creation of a draft letter is ripe for this stuff. It would be awesome if somebody did that, tucked that away, and then back in November when this opportunity came up, that was the source for one, and then the second was as we've been showing the initial tool we built does the analysis for state statutes, the 50 U.S. states. But then we meet with the hospitals and healthcare organizations, and we added in HIPAA. We were getting a lot of requests then from banks and financial services to add in Graham Leach Bliley, New York Department of Financial Services, other areas. So again, another opportunity. So all of this. I was thrilled when we got the opportunity to participate in it, but I think what it hides a few things, and then I'm going to let everybody eat. It highlights one, there's tremendous opportunity in the market and in the legal profession to build these new mousetraps. I started with one client request a couple of years ago, and now I've got. I mean, if I had, well, nobody needs more of me. But if there were more of me at Akerman, we'd have at least another half dozen tools up and running with clients already with clients on board from the start. I was talking with just a couple of days ago with the general counsel at a $3 billion clothing sportswear company who actually wants to partner with us and build a tool around their gifts and entertainment, anti-bribery, anti-corruption. It's an area that she sees at her company ripe for automation. She's actually willing to volunteer some of her time, as anybody that's dealt with corporate legal departments, getting time from your general counsels and your deputy GCs is not easy. But she's actually interested, wants to partner with us to actually to build to build the tool there, and we've got a whole list of other opportunities. So one, tremendous opportunity to build these things and tremendous interest on the part of clients. Two, huge role a huge opportunity, I should say, for collaboration in building these, and this has been a big part of what I've been focused on the last several months. Is finding the places. I mean, the IP project here, perfect example. We got got the idea from a client. We were able to develop a prototype application, no cost to the client, zero cost to the client. The only cost to Akerman being my time, which I was thrilled to provide. The students and Dan and Jordan are phenomenal. And then I'm now I can take this back and show it to the client and say, hey, you know what? Number one, that was a really great idea you had, and here's what it looks like. And even if he never buys the thing or uses the thing, there's value in that. Going back to a client and saying, hey, you had a great idea, and it was a good enough idea that we actually built something out of it. So the opportunities for collaboration among corporate law departments, law firms, service providers, law schools, and students, huge. And third, the last thing I'll say is that it underscores this experience has been very. What word am I looking for? It's great to see programs like LegalRnD here that are teaching soon-to-be lawyers how to build these things. I would, there are a lot of days where I would give a limb to have, an associate or two with some coding experience and who can jump into these. I had the opportunity to spend the time that it took to climb all the learning curves. It would be great to have some younger attorneys so I could leverage for those. And so I think the program here. What the program here is doing is fantastic. I'm very encouraged to see more programs like this popping up at other law schools. I think law schools are slowly figuring it out. I think law firms are slowly figuring it out as well. But if I sum it up in one word, or I'll just say two words. Huge opportunities, and thank you, Dan and Jordan, and all six, Danielle and Hussein and Sean and Erica and Caitlin, and Justin is off at his conference. So thank you all for the opportunity. Thank you for listening to me while you've got lunch waiting, and that's all.